Hi everyone. Today we have with us Rishabh, Sarisha, and Viha, who were adjudicated as the runners-up at the first IBBI National Mock CIRP competition. They are here to talk about their experience in this first of its kind competition. Hi team, it's great to have you here. I request you to please introduce yourselves, after which we can begin talking about the competition.
Hi Niharika, this is Rishabh from Gujarat National Law University.
Hi everyone, this is Sarisha Chawla, a third year BBLLB student at the North Cap University.
Hi, I'm Biha. I'm doing law from Maharaja Agrawal Institute of Management Studies. I'm in my second year.
Great. To begin with, please tell us about the structure of this competition and also about your team composition.
For the team composition, we are required to form a three-member team, which could be either an all-university team or a cross team. And for the structure of this competition, basically the rounds are divided into two, that is the preliminary rounds and followed by advanced rounds. For the main competition itself, we are required to submit two major documents, that's the resolution plan and a dossier. For the resolution plan per se, we had to go ahead and form a draft of a resolution plan. What would a company actually do when they go through a insolvency process or liquidation per se? And for a dossier, it was just a compilation of all the legal nuances that a corporation could be facing at that point, followed by also a list of compliance and a checklist per se, which will elaborate further.
Right. So what can you tell us about your preparation journey throughout, and how would you describe your research strategy for the resolution plan?
So the competition involved preparing a resolution plan and a dossier. So we started by thoroughly understanding the law through the BEAR Act, guidelines of the IBBI, as well as commentaries and handbooks. Secondly, we focused on understanding the specific requirements and parameters to ensure that our efforts are aligned with the expectations of the Committee of Creditors and the NCLT. Thirdly, we familiarized ourselves with the company and its financials and how we're supposed to distribute the amounts to the creditors. And having to find a resolution plan over the internet was a near to impossible task. So we consulted our faculty members and experts from the field who guided us through the process. After the resolution plan and the dossier were complete, we divided our roles and responsibilities as the IRP, IRP, and the RA.
Right. So how different would you say this competition was from a MOOC? So with respect to research, the resolution plan in place of a memo or the presentation during the rounds, how similar or how different was it from a moot court competition?
So to answer that question per se, in a moot court competition, you have a factual matrix per se, which goes for a length of what has happened, what is the storyline, and what are the questions of law involved in this. But in a CIRP competition, which we all were doing it for the first time, there was no per se story that was taking place, but all there was only that a company is bankrupt at this juncture. What do you do going about resolving it? So in the first round itself, we had to present a rough plan how to revive the company in front of a committee of creditors. Per se, in the advanced rounds, the forum changed to a NCLT bench where the resolution plan per se got approved and you had to defend the plan saying that it is legally compliant. So per se, it involves a different set of law and procedure to it compared to a moot court competition where you have to just stick to a few questions of law and just go about answering it with a petitioner and respondent. Over here, there were no different two sides. It's just one side that everyone had to focus on.
And except for the legal nuances, we also had accountancy and business operations involved in the process. So that was a different thing.
Right. So can you discuss any challenges that your team encountered during different stages from preparation to presenting? And also please tell us how you tackled them.
So regarding the challenges that we faced, as the competition was the first of its kind, it was difficult for us to understand what to expect out of it. Also, because the competition was the first of its kind, we didn't know how we were going to be judged and what basis we were going to be marked. And also, a lot of resources were not available on the internet, as insolvency and bankruptcy is a niche concept. It's a niche field of law. So a lot was not available on the internet. So we just dealt with it by contacting people who were experts in the field of insolvency and bankruptcy. And we also stuck to the guidelines. So that's how we dealt with it.
Right. Lastly, based on your recent novel, non-traditional experience, what advice would you have for the fellow law students?
I think all of us would have very different sets of advices. So I'll let everyone go, like they'll have a minute or two for them. So, Sarisha.
So firstly, I haven't studied the insolvency and bankruptcy code as a subject till now in law school. I've always been either interning or going through courses over the internet or different law schools. So firstly, I think visit the website of IBBI regularly if you're interested in having a career in insolvency law. Secondly, since there are a lot of changes, I think you need to be up to date with everything that's going on. And thirdly, I think being focused. So there's not a lot of opportunities in this field. So having networking and attending seminars or conferences, I think it's a bonus for everybody interested in this field.
So, for me per se, like I had zero idea about IBC, and being a second year law student, we're not taught IBC per se in such earlier stages. So when I started off with it, so I just picked up a commentary per se or a book in IBC that's by Suman Batra, so who also judged us in finals, surprisingly. So he had written a beautiful journey of how IBC evolved and how it was brought into India from the UK law itself and not from the US. So it showed the shift, how it's based of creditor-centric and not debtor-centric. So reading about it, reading the jurisprudence of IBC helps per se understanding the core of it. Maybe it's okay to not know per se the sections of the regulations, but if you understand the essence of the law, that takes you a lot throughout the competition. Like you're able to answer the questions better from the judges, which are expecting the core of the nuances of law instead of the specific timelines or regulations of it. So understanding the jurisprudence helped for me.
I'd like to add, so with what Rishabh and Sarisha said, they rightly stated that it's very important to have an understanding and a clear clarity of the IBC if you're participating in such a competition. I'd just like to add that it's also very important to be confident with what you're speaking and be very clear with the facts that you've already mentioned and answer the question that the judges are asking you, whether you're aware of it or not, but to have an answer is very important.
All right, team. Thank you so very much for the very insightful session. Your journey, your learnings, and the advice will all be of utmost importance and very helpful for everyone watching it. I, on behalf of ILCC, wish you all the very best for your journey ahead. Thank you.
Thank you so
much.
much.